message do you have for the world, Lori? I know you can hear me.
Hi, Chad. Are you okay? They're at the house right now. Heart's gonna be calling. Okay. What are at the house for? Are they seizing stuff again? They got a search warrant? Oh. Okay. Okay. Is there anything I can do for you? Pray? Okay. I love you, babe. Go to the portal. I will talk about it more. Okay. Love you, babe. Hi, Chad. Chad. Yes, I got it. I got it. Let's see it. Okay. Did you bring it? Okay, thank you. All right. Okay. I got my ring, Chad. The new one. Okay, thank you. Yes. I got it from Amazon. Yes, I did. Thank you. Yes. Where's my lipstick? Okay. Okay. All right. Okay. Okay. Yes. Hi, Dad. Yes, I know. Don't I look good? I know. So good to see you. Yeah, I'll meet you in the portal tonight. Yes. Yes, Chad, I will. I miss you. I know. I know. Thank you very much. I miss you too. Yes. They got me wearing this. I couldn't wear my own clothes. What is up with that? Okay. All right. The judge is in here now, so.
But a person's life is on the line. The prosecutor for the state of Idaho represents the interests of everybody in the state, and that includes the defendant. They are duty-bound to look out for the procedural interests of the defendant, and what they're arguing, in my opinion, Your Honor, is wrong. The state's attorneys here are here to seek justice, not just a win, and they're here to protect the Constitution and the rights of all those in the state of Idaho, including those that they're prosecuting. And so I believe that the appropriate way to deal with this indictment is to return it to the grand jury and just have them split the two conspiracy charges so that it's easier for a regular jury, for a trial jury, to understand and to sort through this. Thank you.
All right. Thank you, Mr. Thomas. I'll hear a response from the state. Mr. Wood, I'd like to start off with the issue raised there at the end that was raised in your responses to both of these motions, that they were felt to be filed timely under Criminal Rule 12B. And let's start there and then move forward with the substance of this motion. So if you'd like to present any argument this time, or notify the court if you're still holding on to your objection on the timeliness issue.
Thank you. Your Honor, we do maintain that objection. That's why we put it in our briefing. We do understand that 12B is a rule in which the court has a large amount of discretion to find good cause or reasonable neglect. However, the reason why we filed that is in neither of the defendant's pleadings was any good cause or reasonable neglect provided for why these were untimely. I do take issue with the idea that the state was late in discovery. We had already provided all of the discovery to co-counsel, and so I take issue with that. Yes, we do maintain that objection, understanding the court has wide discretion on that issue.
The argument on that. The court's reviewed that objection. It's made under time frames that are set forth in Rule 12. In particular, Rule 12B of the Idaho Criminal Rules indicates motions under Rule 12B must be filed within 28 days after the entry of a plea of not guilty or 7 days before trial, whichever is earlier.
Judge Boyce, can I take these off? They're hurting me. Thank you. Thank you. Yes, thank you. Bailiff, please get them off. Thank you. Thank you so much. Thank you. Okay. I know. Thank you, Your Honor. Where's Chad going? What are they doing with Chad? Where are they taking Chad? Oh, because I have my handcuffs off. Oh, okay. Chad, I got the ring. Chad, meet me in the portal. That DA is a Fort Dark. Meet me in the portal tonight. Bye, Chad. Bye. Thank you. Thank you, Your Honor. Carry on.
These are not within that time frame. However, that Rule 12D also has an important final sentence. The court may shorten or enlarge the time and, for good cause shown or for excusable neglect, may relieve a party of failure to comply with this rule. I've considered that objection and looked at the objection as well as the discretion built within the rule under 12D. And I do find, as it relates to both these motions, that good cause has been shown for the timing of the motions. One is the complexity of the case and volume of discovery. There's been delays through no fault of defense counsel with their client having been found incompetent for some time and then returned to competency for further proceedings. The court would note that trial is not scheduled in this matter until January, so we're still significantly before the time for trial. The court would also note that we discussed specific dates for the calendaring of these motions, along with the input from the state as to when these would be appropriate to be heard. And that rule goes to the filing of the motions, not necessarily the hearings, but given that determination and my discretion, I think it's important that these issues be determined on the merits and not procedurally under the rule. And so in my discretion, I am finding good cause exists for a factual and legal determination on both of these motions today. And so I'll deny the objection as it relates to timeliness. Finally, on that discovery issue raised, I don't take that into consideration at all because there's been no motion to compel filed or any other notice to the court that that's at issue. So with that ruling made, Mr. Wood, if you would like to now present your response as to the merits of the motion on counts 1 and 3.
Thank you, Your Honor. Going through the defense's motion, it seems that the primary concern is this is going to be confusing to a jury and unfair. The state just fundamentally disagrees. The defense's argument rests on what appears to be a false premise that a conspiracy to commit multiple crimes is in fact multiple crimes. I've outlined this in my brief, so I don't want to go over it word for word, but I just note that multiple cases have held, and this is just a few of them, that the conspiracy is the crime